immigration. If you go back to both immigration and education, on immigration, you had waivers or parole, and on education, you had states. And those counterplans solved so many Fs that writing an F was all about trying to find a Fed key warrant or a Congress key warrant or a visas key warrant or whatever on immigration. And on this topic, like some bad Fs will lose to the state's counterplan, but every topic area has so many federal laws that it could decriminalize federal agencies. It could change the policing or forensic science guidelines for. And because they're federal agencies, the states can't fix them. And so that's going to make it pretty tough to be negative, especially when already most of the literature, like 90% of whoever writes about any one of these, is going to be in favor of the F. And the only kind of generic ground that's guaranteed is probably the abolition K. Although even that could potentially be an F, although probably not based on some of the T stuff we'll talk about shortly. But that's pretty bad. The perm is pretty threatening against that. Most of the alts are probably less likely to resolve whatever harm area than the plan. And it's just not a very good T topic in terms of like using terms of art that have a hotbed of people arguing multiple positions for what these terms mean. So you're gonna have to learn as a 2N to make a lot with a little. And we're just gonna go through every part of the topic and see how we can limit it down. Because I do think that this is an awesome topic area. It's really interesting. And if you can wield a wide arsenal of T args successfully, you can parse the topic down to limited enough form that you can write good case next to what's left. Enact. One basic interp, and Dehyde covered this in his previous T lecture. Almost all of the EV is new, other than maybe a couple of cards that he talked about. But I'm not going to do a ton here, especially because I think this is a pretty weak argument overall. But one of the arguments he previewed was that Enact can exclude agencies or courts. I think that a more strategic variant of that is just excluding agencies. This piece of law evidence says that the word enact applies to judge-made law, so that courts would be topical actors, but agencies wouldn't. And this is nice because I think one of the worst types of AFs to debate from NEG perspective, and worst just meaning hardest, is an AF that internally changes FBI policy, internally changes DNA collection standards, internally changes prosecution enforcement guidelines for asset forfeiture or something like that. If you make them use either Congress or the courts, you have an elections link, politics link, court politics link, stuff like that, potential counterplans based on the agent as well. And so applying this violation to stuff that only has agencies act is going to be really important. There's a couple of additional cards that are pretty good for this. This Clement card, and both of these are from state courts case, one state courts case and one state case that made it up to the federal level and has the Solicitor General, the chief lawyer in the US, actually writing an amicus brief for it. Both of these are literally about what the word enact means in the context of agencies. And one compares it to administer, says that a legislative body is what enacts, whereas agencies administer, and it's broader. The other one explicitly answers a Neil Schaefer card. It's actually going to be probably a common one for the yes, agencies can enact side of things, and is like, no, this is wrong because of the word enact. That the word enact denotes legislative enterprise. You have to have a legislative body with people actually voting and going through the process for it to happen. So that'll be pretty good, just in terms of limiting down the range of AFs to things that use the courts or statute. Some people are going to try to use the word enact to mean statute. This is another card that Dave talked about. This would be a nice interpretation just because like process counterplans all become competitive. If the word enact has to require going through a legislative process exclusively, like you can't use the court either, then you're in a good position with your court's counterplan, and you have a T option against all court stats, which are going to be very common. There's some decent cards for it. And there's some additional cards that you can use as like a 2NC trick. Like I cut both of these and I just kind of included the money lines from each of them. If you're debating a sentencing app, you could be like, CJR has to be comprehensive. And I found this one card that's like, comprehensive sentencing reform by definition requires statutory changes. And so now you need, as the AF, multiple pieces of counter-interpretation evidence that counter-interpret each part of the resolution as including the authority to use non-statutory means of planned passage. So that's kind of a tough one if you don't have those cards available offhand. That being said, I think this interpretation is just pretty bad. Like the comprehensive thing that I just displayed, it's pretty plain that criminal justice reform lacks a comprehensive definition, as the Figler card attached here just says verbatim, criminal justice reform lacks a comprehensive definition and therefore means many different things to different people. Pretty plain. And then broadly, I think the cards that are like courts enact thing all the time are just devastating. Like this right card says that not only the California and Delaware Supreme Court, but many other state and federal appellate courts, and it's a longer card, it goes on to say more too, commonly refer to court enacted rules. And so if this says the courts can enact things, then clearly courts can enact criminal justice reform. So I wouldn't really rely on this one. I think it's going to be difficult to get process counterpoint competition. I think most AFs in the post-2007 debate environment have no reason to ever put anything besides United States federal government in their plan text, and can probably, even if they probably have to defend eventually some link to some agent disad, are going to be able to win the competition debate against agent counterplans unless they unnecessarily specify. Substantial. Wow, this is a useless term. And I don't usually think that. I'm actually probably a stronger proponent of T substantial than many people out there. But substantial in the context of criminal justice reform means nothing. And I hope I'm wrong. Shoot me some evidence if you find any to the contrary. But it really doesn't. It's a little bit of a false hope, and Dee had mentioned this briefly in his Q&A, but kind of have some supplementary evidence here to kind of demonstrate what he was talking about. There's a little bit of a false hope when you first Google substantial criminal justice reform, like maybe you just put that term in quotation marks for like a home run search, a billion things pop up. And you're like, oh, maybe this means something. Almost all of those searches refer to the First Step Act, which passed in December 19, and it referred to basically a Justice Department official and then another lobbyist who both called it the most substantial criminal justice reform legislation in a generation. This is pretty bleak because this only applied to, or at least parts of it only applied to 3,100 people. And so already you're kind of talking about a piece of legislation that referred to a tiny subset of the overall population. The other problem, before I go on to maybe a couple of other potential bad T substantial arguments, is that there's a baseline issue. When you say substantially or substantial means X, you're saying that of the overall amount of criminal justice reform, you have to do a substantial amount of it. The problem is criminal justice reform isn't like arms sales, right? Arms sales, you can count it up. And we have problems with that. Everybody remembers the SIPRI definition debates, like does it count small arms? What unit is criminal justice reform even trying to measure? There's no definitive list of criminal justice reforms out there, and then you can say substantial is this amount. And so there are all types of crimes and punishments in the criminal justice system outside of prison. And so even like amount of incarcerated people affected isn't really a quality baseline, because lots and lots of people are, for example, they're felons who can't vote, or they're people who aren't in prison right now, but they've been put in prison before, or the people who'd be affected in the future. It's just like, it's impossible to quantify a baseline upon which to measure substantial. There is maybe a substance versus procedure definition that you can make. I attached a couple of cards here. I think the only way you can make this viable for the neg is by trying to exclude procedural reforms. So stuff that doesn't actually help anybody in prison or anybody who's being punished now, but changes the process or procedure in the future. Maybe. I think it's pretty weak. And the Marcus card attached under this Venerio card literally says that the federal rules of civil procedure was itself the most substantial procedural reform in U.S. history. It said it transformed civil rights and civil and criminal justice litigation elsewhere in the card as well. So I don't know what that could be. The last thing I thought of was maybe material qualifications will make a comeback. There's like a classic debate staple card that substantially means without material qualifications from Black's Law Dictionary. And usually this means any further clarification to the words in the resolution is a material qualification of those words and therefore means it's no longer substantial. The two problems with this card is that one, it's just like unclear and bad and not specific. It's not about the topic at all. And second is, I think it's technically defining substantially. Remember, the word in this topic is substantial. But you could use that to potentially aid in the construction of a subsets violation, which we'll talk about in a little bit. So moving on to criminal justice reform. The most important violation is, I think, justice reform is progressive and excludes punishment. So because criminal justice reform can mean so much, and it can potentially bidirectionally include both changing the laws to make them more harsh towards offenders and changing them to make them more lenient, I think it's really useful for the NEG. So if nothing else, they can prep their generics that harsh laws are good and deter crime. That justice reform is only progressive or rehabilitational. The best card for this I've seen so far is this piece of Evans evidence. This guy did a study on the overall relationship of basically punitive state laws for kids and overall youth offenses. And for the study, he defined his terms such that the use of laws, policies, rules, and regulations to advance a more progressive approach to justice is what criminal justice reform entails. And he says that if you make justice reform so broad that it would include stuff like increasing police surveillance or imposing stricter sentences, it would make the term, quote, meaningless. Well, almost meaningless. This is a good card. It sets up a pretty good debate argument. The problem with this is always going to be stuff like the card's just not definitive or contextual or predictable enough. Notice that the qualification of that card was just some guy writing a study, and he's qualified, but it wasn't from a court, certainly wasn't from US code. This is just from a law review, so really not much different. And I think maybe the AF will need better quality cards to win that we're like uniquely the only ones who are predictable. But I think that a more representative consensus approach to defining what reform means is this piece of Tonry evidence that's like reform is multi-directional. It says that it means different things to different people depending on whether or not you want it to be softer or tougher or whatever. And so a bunch of cards like this, including some maybe from statute, and I think that definition is difficult to execute, but it's a key one to, I think, prep and hopefully better cards come out, and perhaps you'll find them yourself as time goes on. Another criminal justice definition is reform excludes abolition. I think Di talks about this in his lecture as well, so I'm not going to reinvent the wheel here, especially because I think it's pretty self-evident and plain. But basically, prison abolition F is potential affirmative, right? That changes and reforms the criminal justice system in a radical and revolutionary way, which is too bad because you want that to be your core generic because it's like the only one on the topic, and it also just means one more set of things to prepare for. There's a Bennett card that Dave put out, but also I think this Patashnik card is one of the better ones I've seen so far that defines reform as making more effective or making government more effective or equitable at meeting existing goals. And so it says that the existing goals are what constitutes the core relationship between reform and its target. So for reform to be reform and not something more, it needs to use whatever the government's goals currently are. Which I think limits it down to, we have to have the same type of view towards keeping the punishment paradigm in place. We just need to make it a little bit more effective at its goal or equitable. One brief violation is that criminal justice excludes juveniles. It's a little bit ironic because 2 slides ago, if you remember, this piece of Evans evidence actually is about juvenile confinement. That's right. For AFs that maybe try to target school discipline or youth offenders, there's a piece of Woodhouse evidence that's like criminal justice means prosecuting and punishing crimes. The juvenile delinquent system or juvenile justice system is what handles delinquency for either stuff that's not a crime if committed by an adult, like skipping school, or stuff that's crime if committed by an adult, like battery or theft. But if you're young enough, then it's handled as a civil matter and you go to juvenile hall. Stuff like that is not criminal justice reform. It's juvenile justice reform. Now, that being said, this doesn't even exclude one of the better AFs in this area, which is like stop trying juveniles as adults so much, but take what you can get. In the US, just briefly, one thing about this topic that's interesting is it doesn't use the word it's. It doesn't say that the US should reform its criminal justice system. It just says that it should enact substantial criminal justice reform in the US. And so where that entails can be up for some debate. I'm thinking 2 specific expansions, maybe 3. Military bases and Indian territory, I think, will be potential AFs, and they'll be especially attractive just because they're both Fed key, like it's harder for states to solve them, and so they're kind of perennial debate AF targets as a result on domestic topics. Embassies is potentially a third. There are definitions that disagree with this, attached one kind of in the military context here that says that all the stuff is outside of the US, but realistically, you know, these definitions are okay. I think it's going to be useful to have them prepped for the first couple of tournaments so that if you don't have time to do for like Green Hill and Wake in the initial tournaments and stuff, a whole neg to military bases and a bunch of different kind of tribal criminal justice systems, you at least have a T violation. One brief thing about in or more of the following, in one or more of the following, is that it doesn't have the word areas in it. Like if you're used to looking at debate resolutions, you might typically be used to seeing. It just says in one or more of the following, but leaves up for debate what those following things are. I'll bring this up again when I get to kind of the subsets definition, which will be like the biggest one I talk about overall. But brief note there. Forensic science, honestly, this is one of the areas that I've had most difficulty in constructing quality T-args. It's broad. It's really, really broad. So like if you've listened to Val's lecture or looked at the Michigan Starter Pack stuff that's already present, which kind of has to do with CODIS, a federal database that kind of combines a bunch of different, or it has a bunch of different individual agencies' DNA databases combined and organized together. They're under the auspices of the '94 DNA Identification Act. That's just one area. Everything from digital computer device evidence to firearms, like the ballistic tests, to toxicology, all of this is done by all different types of federal agencies and regulated in different ways are going to be AFs. And you can change them in a variety of ways. Yikes. Policing. This is the area, and it kind of blurs into sentencing a little bit. I think there's kind of more overlap between those two than there are with forensic science. This is the area that I think actually has the most potentially devastating limits explosion. And it's mainly what I'll call the decriminalization question. So under either policing or sentencing, it seems reasonable that maybe topical plans could be like, plan, USFG should remove incarceration as a punishment for marijuana, or remove fines as a punishment for something that's currently only penalized by fines. Now, this allows you to basically take anything that's illegal in the US and make it legal. That's a lot of Fs. There are some solvency issues with it. Like, for example, you can't really make things legal. You can only decriminalize things, which means you probably can't be like, states that make this thing illegal, make them legal, unless you actually have the courts rule that something should be decriminalized on constitutional grounds, which would allow you to probably get a law around that question and actually solve state laws too. And then the lack of legalization, especially in the drug area, you know, the fact that you can't actually set up markets and taxation schemes without, I think, plainly be extra topical, is a little iffy, makes it a little bit harder to solve. But I mean, still, look at the number of things that you could potentially do. I spent like an hour putting this list together, and that is just scratching the surface of only things that are illegal at the federal level in some capacity that you can make legal. Right? Drugs of all sorts, every type of drug, and like kind of subsets of drugs, like whether or not it's legal to use steroids in sports, prostitution, physician-assisted suicide, sales of human organs and tissue, and online gambling. All 5 of those were topical areas, and that was the entire legalization topic in college in 2014. But also stuff like, vagrancy or homelessness or street gambling. Basically, there's no good justification for any of those things being illegal. They're disproportionately enforced on people of color. Abortion restrictions, so like a seminal Supreme Court case, Planned Parenthood versus Casey, which on the 2005 college courts topic was literally one of the only 4 topic Fs. Like this case by itself was a 4th of an entire college topic, saying stuff like abortion should be restricted for, in the sense that you have to delay for a few days before getting an abortion. You have to have spousal or parental consent. You can basically overturn those restrictions by saying, nope, anybody who conducts an abortion without going through those requirements, it cannot be punished by any criminal punishment, and have the Supreme Court do that on the grounds that Planned Parenthood versus Casey was incorrectly decided. You can affect immigration, penalties related to HIV status, even archaic laws, which is one of my favorites. So like, for example, there's a law in Michigan on the books that says any man, who seduces an unmarried woman is, I think, I didn't write it down here, but I'm pretty sure it's punishable by up to 5 years in prison and up to a $2,500 fine. And prosecutors actually cited this in a 6-year period up to 30 times. And they say they're only using it when they really need to in a case where you should trust us. But it's like, why not just make everything illegal and trust the prosecutors then? And then, and that AF won't be an AF because Michigan counterplan solves it. But if there's any stuff like that at the federal level, that's another kind of AF area. And then finally, economic crimes, like insider trading, people want to make illegal. Then there's even more AFs that if you allow bidirectional AFs into the fore, which we talked about how to exclude earlier, you can actually increase sentencing and functionally make stuff illegal by enforcing bank fraud and securities fraud more, by establishing mandatory minimums for sexual assault, or an AF that has the inspector general increase the ability to enforce abuses by the executive branch. So how do we limit these AFs out? Because I think there's a clear interest in trying to do so. Well, one basic way, have policing be defined narrowly as requiring an increase in police accountability. Both of these pieces of evidence are I think, the 2 best I've seen on this so far. It says that police reform is stuff that, in the first case, refers to action taken to change police behavior considered inappropriate, so searches without warrants, illegal detention. And the second one uses the accountability phrase that's in kind of the top level tag of the argument. I like this because this says, hey, what the law isn't about policing. What policing entails and what reforming policing entails is changing the organizational structure for how police enforce whatever the law happens to be. Now, it's not really written with an intent to exclude. Like none of this F says, oh, and police reform doesn't include making, marijuana decriminalized. But it's okay, and I think can establish extra T and effects T violations as well. Policing reform excludes police reform. So this is kind of like an answer to that previous T-arg, but it also is another neg-arg in and of itself that you should have kind of both prepared. This piece of Davis evidence makes a distinction between police reform, which, if you'll notice, technically both of these cards find police, not policing reform. This Davis card says that police reform is just about what individual officers do, and policing reform is a focus on the structural culture and practices of overall police organizations. And so establishing not establishing, body cameras basically is excluded. And I think potentially you can use this as a subset style argument. That's like, you have to basically reform all of policing, not just one law in the book. Now, this is a basic 2AC card that's kind of our enemy when we're constructing interpretations to limit out the wide range of potential Fs. This TA card is like the use of state power by delegated authorities for the purpose of law enforcement and the maintenance of order is what policing is. And that defines maintenance of order as saying the management and control of minor offenses and behavioral disruptions that might disrupt or threaten the status quo. I like that card for the AF on all of these decriminalization AFs because it's like literally policing means maintaining order through making petty or minor offenses punishable with jail time, for example. And so changing that seems plainly topical under this interpretation. So this is kind of, I think, the standard that you're up against when you're constructing interps to the contrary. So the last thing that we're going to talk about, and kind of my big, thing that I'm going to float for the rest of this lecture is maybe there's a role for T subsets on this topic. I think there's going to be a lot of pushback from debate coaches and kind of people in general because the cards are not going to be great for this. But I really think that this is maybe one of the only ways that we can limit an otherwise unwieldy topic. So subsets just means that you have to reform all of sentencing, policing, or forensic science. You can't do a subset of it. You can't just change one law, can't just change one DNA database. You have to make an AF that changes the legal standard for all of it. You can actually use a lot of the incredibly broad criminal justice reform cards to the detriment of AFs. I don't think this is the best example for it, but it's like a very brief one-line example. The Shinar card is like, criminal justice means the entire complex of institutions and people involved in dealing with crime and criminals, everybody. So every AF has to do all of the area and affect the entire complex of institutions. I think the best card I've seen for any of the areas for what this means is in the sentencing reform context so far. This rights card says that sentencing reform means, quote, wholesale change, better legal structures, better process. And I almost think that the way you want to phrase this TR is that you have to change the entire process of a topic area overall for an AF to be topical. Now, are the cards going to be great for this? No, but the AF cards are not going to be amazing either. And I think that as we accumulate enough evidence that kind of makes this mildly persuasive, this could get pretty topical because the case for it is really persuasive. Like, there are still so many ways you could reform criminal justice in any of those areas by changing the evidentiary standards, by changing, for example, the strict scrutiny standards that are required for policing, by changing the grounds that are needed for plea bargaining or asset forfeiture, or there's like so many different areas that you can use and apply to the entire of a topic area. Now, I think actually the biggest problem with T subsets by far is that it's a lot of times hard to establish a violation. So a lot of times AFs can just use resolutional wording and write an AF like, the USFG should enact substantial marijuana criminal justice reform in the area of sentencing and or policing. And then it's like, well, our plain text in a vacuum just does whatever those words mean. And so, we just apply like marijuana reform to the whole area as a whole. That being said, though, with enough evidence, T substantially is out met quals, kind of putting everything together, you can almost make this as like a topical spec style arg that's like adding any additional material subset to the topic area that says that this only applies to a small area of the topic overall, or like of that area overall, is the violation. And so adding that to your plan makes it so that it doesn't meet our violation. And then kind of make the limits case that I think aggregating all of the slides from before, you can very easily put together just because like there's so many cases out there and it seems really just unwieldy, especially without any united net ground possible to prep for all of them, at least with like something good to say. So if you have nothing better to say, subsets is a good interpretation, and I kind of hope it catches on and maybe encourages AFs to be a little bit broader and more process-based. But That is my allotted half-an-hour period. And so I will now open the floor to questions. And hopefully this gave you some additional research and background into the topicality process, or the topicality debates on this topic.
Thanks, Kevin. That was excellent. It provides a lot of insight on the topic. So we have a few questions coming in. If you have any more, just hit the Q&A button at the bottom and type it. So first question, which is kind of answered a little bit, but how do you think bidirectionality will play out in the topic, and what might its benefits be for more strict CJR?
So I think that some people will try to do bidirectional AFs. I didn't talk about any of these examples at length, but almost all of these examples have pretty robust solvency advocates. And insofar as there are any topic generics, and probably the best are stuff like, the link direction on elections, for example. Most of the elections links for November are going to be like, Trump has a moment where he looks almost sane and makes all the suburban moderates who need to vote against him for Dems to win be like, oh, actually, this is, this Trump thing's not too bad. He's not crazy. He's actually doing something that looks pretty smart and pretty reasonable. If maybe he did something that would actually upset his base and confuse people, it would allow for an effective elections link turn. So I think there's a strategic reason just to avoid, insofar as there are any neg generics, you avoid the direction of the links for those, and so people will try to do them. It remains to be seen how good the neg T violations can get for like CJR is progressive. I kind of hope we find some court-based EV, or at least law review EV, that has a holistic legal definition as opposed to like individual studies being like, for the purpose of my study, I define it as progressive. The better the cards are, the more viable no bidirectionality violations become. In terms of its benefits, I think that the debate case is pretty straightforward. Very unlimited topic, very hard to be negative. You need limited sets of negative ground to prepare so that you only have, you only have so many disads. The links for those disads need to be the right direction for any neg prep before the year to work at all.
Awesome. So based off that USC 19 evidence that you were referencing earlier about military bases and Native American territories, does the USFG have jurisdiction to reform criminal justice in Native American territories?
It's a debate to be had. Certainly with a court's actor, you could establish the legal jurisdiction to do so. There in 2001 to 2002, I believe, or it could have been the year before or after, there was a college debate topic that was resolved. The USFG should substantially reduce its control over Indian country, I think was the text of it. And so the entire next side of that was like, here are the reasons that the US should control and has legal basis to control it. So you could, but there's actually a lot of neg ground against that. And so I don't know if AFs that increase control would be the most strategic.
Okay. So if decriminalization ends up being topical, do you think things like refugees and EB visas from the immigration topic will be as well?
I think that stuff like that would specify so much that it would make any variant of those subsets or process-based violations a little bit more palatable, just like you specify so much that this doesn't really become about criminal justice reform as much as about changing a particular law. I think it's not really sentencing or policing to increase the number of visas allotted. You can only really it's like the waivers or parole counterplan is a little bit closer to being topical than the increased visa number AFs would be. I actually do think there's a case for some of like the Endelman and Meta articles, which are basically like, here are creative ways that the DOJ or custom CBP or U.S. Or DHS or Department of Justice or all these agencies working in tandem can creatively interpret the law in order to let in and selectively enforce or non-enforce a bunch of immigrants, or selectively enforce non-enforce those laws in order to let in a bunch of immigrants. I think that those apps are probably better than increased visa numbers, and those are probably some of the more strategic immigration mechanisms you could write if you wanted to get access to like a broad array of basic advantages.
Also a good reminder to keep those immigration files handy if somebody reads it.
Never get rid of debate files. Back files are so helpful.
You got any thoughts on whether or not we should have numerical definitions?
I mean, we should in the abstract, but we really can't because there's no baseline. Yeah, I mean, everything's probably more persuasive when it's quantitative. If you have clear and stable baselines, then you can't just make subjective interpretations or standards up. You have kind of facts on the ground to account for. It's almost impossible to do. Maybe you can try. And so I'm sure that people are going to produce and read like a substantially means you have to affect XYZ amount of incarcerated people definition. It's just not going to be very good because of the baseline problem described above.
It also seems like it's tough because of the number of people that are in state and local criminal justice systems that you would never meet that definition. No app could meet that definition.
No. Now, maybe that's a way you can construct it. Like you have to affect XYZ people in federal prison. But I mean, people in state prisons can potentially be affected, or at least state laws can be overturned by a court decision that says this state law is unconstitutional, or by a new law that says that policing or sentencing has to be done in XYZ manner because federal law supersedes state law due to the supremacy clause. And so, like, it just becomes difficult to account for that. I will say something on sentencing that I wanted to briefly remark that I didn't have time to, that's a little related, is I think it's possible to exclude some sentencing reform suggestions, like let people who are currently in prison due to nonviolent offenses out. It's like one of the most common proposals. You could maybe say sentencing only entails the act of sentencing in future trials. It excludes pardons. It excludes appeals processes and stuff like that. And so maybe you could, like, you have to keep people in prison that are currently in prison. There's no topical mechanism to solve that stuff. Is like a potential T argument as well.
I'm going to merge two questions together because I think they dovetail well. The first one is, what implications do you think T effects and extra T will have on the topic? The second question is there a case for retroactively applying legislation to release prisoners?
So I'll start with the second thing, just because that was what I was just talking about. Yeah, there is a case. I mean, the broader definitions of sentencing and policing, like taking a look at this, the use of state power by delegated authorities for the purposes of law enforcement and the maintenance of order. It is the management and control of minor offenses that may threaten the squo. And so it seems pretty clear that law enforcement entails, the Bureau of Prisons entails all of the actors that keep people confined in order to deter crime and maintain order in the future. It doesn't say it explicitly here because I didn't prepare one to include retroactive release. But I mean, there are for sure going to be cards that say sentencing reform and policing reform both entails retroactive release. It's just that you could have cards that are interpreted to say the contrary, and I'm in the business of trying to eke out and make maximally persuasive every angle that viably limits the topic a little bit farther. But those are for sure potential topical Fs. They're just, I think, more potentially excludable than some other Fs that are, like impossible to exclude. The extra T and effects T question, I think these Bailey and Bonner cards are probably the most textbook examples of violations that you use. So like, let's say against the marijuana app, the one AC that I put out, you read these two cards. And let's say for some reason, the marijuana app didn't say that they were sentencing, they just said that they were policing. They're CJR for policing. these cards say that police reform is just changing police behavior. It's not changing the law. Changing the law, if you do that, if you change the actual schedule of drugs that police then enforce, would be extra topical under this. It would be effects topical if perhaps it would cause police to change their behavior, because, you know, any act that would down the road cause some future topical action is what effects topicality means. You know, one is topical by effects if they cause future topical actions but don't fiat them itself in the plan text. Extra T just being you do stuff that's topical, but you also do stuff that's not topical. And the not topical stuff here would be changing the laws, which is not entailed under the kind of narrowly defined police reform premise. So I think one of the more common ways people can define police and sentencing reform is in a way that makes the violation against decriminalization acts effects retro T based. The reason these are going to be hard to win throughout the year, though, is because acts are going to be like, we should do marijuana sentencing and police reform. And, you know, that changes the boundaries of police discretion as per your Bonner card for what it entails potentially. It changes the warrants, the process for how you go about searching without warrant for marijuana if you win this T violation. And so it makes it so hard to, you'd have to basically win the entire T violation only to make the plan mean something else and then win the debate on substance afterwards, which makes it so onerous to be negative that it's hard to win on stuff like that. But, you know, you could make the argument that plan text in a vacuum is bad for that, for the very reason of the scenario that I just game planned out, and still win it accordingly. But it's harder.
This segues decently into this next question. Do you know of any federal statute for criminal sentencing that is a catch-all for defining these terms? It seems like we're kind of building off of a series of other laws and court cases.
Almost everything that references a specific court case references a pretty wide range of laws. So let's see, for this Tonry card is about federal sentencing guidelines. It doesn't define sentencing reform, and I think one of its criticisms of the federal guidelines is that it doesn't have a definition of sentencing reform. CJR, it's like laws don't define reform so much. Reform is usually something that advocates of changing law internally are debating about what it should be. There's no reason usually to write reform into laws. And a lot of the laws will be called blank reform act, but you know what the law actually does and the penalties it enforces or makes more lenient, those are the key terms to define for the law's purposes, not like reform, the word reform itself. And so there are a lot of court cases that go back and forth on what some of these words might mean, especially sentencing and policing. But I don't think there's like a catch-all federal law that would give us, you know, the best definition.
And it seems like most of the reform literature is probably going to come from law school professors writing in law reviews about what their takes are on reform, correct? All right, a couple more questions. If you were going to approach this topic as a 2N from any angle, where would you start in prepping T?
Definitely subsets versus every area of the topic. And I would try to define almost every word in the resolution so that in the block, I can have a wall of cards and tricks that are like CJR has to be like broad, structural, the entire area. Sentencing, reform, which, you know, two words on topic together mean that it's the entire area. Substantial, enact, the lack of the word area means that it has to be all of that. I would include all of these tricks and kind of put together the best case that's the most difficult for the 1AR to answer, and I would arrange the best cards that say that it has to be the overall process. And then I would supplement that with TVAs that list clear examples of what overall, you know, non-violating reforms would be that actually change the process and procedure at all levels of that area, as opposed to asks that are smaller. And then I would finally cut violation evidence against the most popular cases that's like, this is only a small part of the overall reform area. And so it's going to be a very subjective qualitative T violation, but with all that F together, you can kind of make something pretty persuasive. I do subsets first. I do bidirectionality second. That reform has to be progressive. It can't be retributive or retributional. And then I would just kind of get as many good violations, like little things like excludes juveniles, excludes this, excludes that you'd only use maybe once a year when you happen to hit that F, but kind of arrange all of those so that you limit out huge chunks and kind of make a case list of what's left under all of these and start cutting case next to the rest. But I think I would do those 2 violations first, so I had something to say against most things, and then I would kind of just go smaller and hit all the niche ones.
How often or how frequent do you think teams will have to debate against a bidirectional F?
And it does depend a little bit on just like the course of T research. So if people find way better T cards on one side or the other, that'll shape kind of how people read things at camp and how the year kind of goes out. People like just going against the grain. People like having something that's tricky. And the TF is going to be good enough to, I think, make 2As feel emboldened to try out bidirectional Fs. So I think a decent amount, but I mean, I would say, policy Fs, probably I'd be surprised if it eclipsed 15 or 20%.
All right, last question. What counts as material qualifications?
That's definitely, the tree falls in the woods, but no one's there to hear it. Doesn't make any sound. It's open for interpretation. The most rigid interpretation would say that any further clarification that means whatever term is being qualified only applies to a certain segment or a certain application or subset of said term materially qualifies it by saying that the material of that term is XYZ. And so material qualifications is basically a synonym with specification under that reading. There may be other ways to interpret a pretty broad and honestly cryptic phrase, but that's kind of the canonical one.
All right. Well, great, and thank you very much, Kevin. For any of you who have not yet committed to a camp, if you have interests in Michigan, please look us up at michigandebate.com or bring any questions you have to Aaron Call at akall@umich.edu. Otherwise, thank you and good night.